evening, everybody. I'm glad you could be here tonight for the 2013 CPLR update. As best we can over the next 3 hours, we're going to go through a lot of the significant cases regarding civil practice in New York over the past year, a lot of interesting Court of Appeals cases. Along the way, we'll try to give you some practice points, some tips that hopefully can help you out in your daily practice, give you sort of a way of thinking about these cases, and hopefully also avoid some of the pitfalls that brought down some of the lawyers and the parties that we'll be talking about today. We really have, as litigators, a unique opportunity today, and that opportunity is to get some insight into how the judges see the cases, because we have a terrific speaker with us today. He was an Associate Justice of the Appellate Division, 2nd Department since 2008, after serving as a Justice of the New York Supreme Court trial and appellate term since 1995. While he was a King Supreme, he served as administrative judge, innovating the creation of new rules and procedures. He also presided over the jury coordination and trial assignment parts, where he settled hundreds of trial-ready cases valued at hundreds of millions of dollars over the course of nearly 18 years on the bench. He developed a reputation, I can attest this is true, as a calm, intelligent, fair, hardworking judge. He is a prolific writer, including co-authoring New York Trial Notebook, a comprehensive trial practice treatise, and he also was an instructor for many years at the New York State Judicial Institute, where he taught the new judges the art of judging. Recently, he stepped down from the bench and now is using his expertise in settling cases at jams as a mediator, and we're proud and fortunate tonight to have Justice Ariel Belen with us.
Thank you, Richard. Thank you very much.
So not only is Justice Belen an expert in analyzing these cases and offering the insight that courts have into how they decide the cases, he actually was on the bench for a couple of the important decisions that we'll be talking about tonight. And I want to start with one of the last decisions, I believe, that the judge wrote, the Rivers case. It's on page 7 of the materials that were handed out. The backdrop is this. As many of you know, before the 1980s, there was no requirement in New York civil practice whatsoever to make any disclosure of expert witnesses prior to trial. It was truly trial by ambush. Witnesses came on the stand. You didn't have to say what they were going to testify about, who they were, what their credentials were. They came on the stand, and defendants would be outside, or plaintiffs for a defense expert, making phone calls. Here's the expert. Go get me some transcripts in the next couple of hours and get them here by lunch, and that's what I'll use to cross-examine. That was changed in the 1980s when, as part of a lot of medical malpractice reform, but also this carried over to all cases in New York, 3101D of the CPLR was amended to include responsibility to provide expert responses. Those of us who practice every day know that those expert responses, at least downstate here in New York, it's a little bit different upstate, are very rarely provided prior to the note of issue. And the de facto rule, like if you asked a lot of trial attorneys, when do your expert responses have to be in by? They'd say 30 days before trial, as if that were somewhere in the statute. It's not, but in many respects it's become sort of an accepted standard. And we all were living with that, I think, quite well until a few years ago, when all of a sudden an argument that I had never seen before came up in the context of a summary judgment motion. Defendant, let's say on a slip and fall case, has an expert. They've served the expert prior to the note of issue. Now they move for summary judgment, and the plaintiff either has an expert who they have not yet disclosed, as would be their current practice, or they say, this is interesting. I hadn't thought about some of the things the defendant is now raising. I better get myself an expert to try to defend this summary judgment motion. And all of a sudden, the courts said, well, wait a minute. You never served an expert response. You filed a note of issue and a certificate of readiness. You said that no discovery needed to be done. And you hadn't complied with your responsibilities to provide expert response. We're not going to consider the expert's affidavit. And all of a sudden now, the timing of expert responses and the note of issue and summary judgment get jumbled and tied together. It's been confusing. There have been a lot of varying cases about it. And a few months ago, the 2nd Department, in an opinion authored by Judge Belen, to some extent, and I will say to some extent, because I have many questions about it, but we have some analysis, the best analysis in my opinion by far, and some clarity on the point from the Second Department. So Judge, if you could tell us about how this case came and your thoughts on it and your opinion.
Richard, thank you for that introduction. This is a medical malpractice case, and the plaintiff had sued various parties, and in particular gynecologists, with failing to diagnose her with a form of gynecological cancer known as choriocarcinoma. And the trial judge had, well, the defendants had made a motion for summary judgment, the medical practitioners basically. And the opposition by plaintiff procedurally was that the defendants had not served their expert disclosure before the filing of the note of issue and the certificate of readiness in the case. Usually, in my experience, it's the opposite that's true. The defendants have made a motion for summary judgment. They attach experts' reports that they had served prior to note of issue. The plaintiff has not served an expert response, and now the defendants are urging the court to preclude the plaintiff's experts and, in effect, deny their affirmation or opposition or gut it by virtue of the fact that these disclosures weren't made pre-note. This case was the other way around. Anyway, the trial judge in this case found that the failure to make that disclosure was not willful or intentional and was not prejudicial. And made a series of rulings. I believe I think he granted summary judgment to the parties that made the motion, a couple of them, the ones particularly who had made late disclosure. The plaintiffs now appeal to us.